Welcome to Real Estate After Death, where we talk about everything you should know, whether it be estates and planning and wills and probate and everything in between. May not be the sexiest topic, but one that is critical to know. I am blessed to be here with my lawyer, Raluca. Raluca, what do you do and who are you? Tell me a little bit more.
Thank you for having me, Shanice. My name is Raluca Soika, and I'm the principal of RMS Estates Law, and I practice wills and estates and real estate law in the Greater Toronto area.
Well, thank you for joining us here and thank you for your knowledge. This week, we will be continuing our conversation revolving around what are the type of real estate ownership. So we have sole ownership, tenants in common, and joint tenancy. And today's inquiry would be with all three types of ownership, what happens if someone passes away for each one of them? So, Raluca, please educate us. What would happen?
So, if an owner passes away, it depends on how their property gets distributed on death, depending on the type of ownership. So a sole owner, their property would get distributed in accordance with their will, so the wishes in their will, or in accordance with the Succession Law Reform Act if they don't have a will. It doesn't go to any other person because there's nobody else on title. So that's the sole ownership.
If someone passes away under sole ownership with a will, but there's a mortgage on the property.
That's a good question. So in sole ownership, if there's a mortgage on property, the mortgage needs to be paid first before the property can be distributed to the beneficiary. In most cases, most people don't require that the actual property gets distributed to the beneficiary. They're content if the property is sold and the net proceeds get distributed to the beneficiary. So that's more often than not what happens. But in the interim, until the property is sold, the mortgage needs to be serviced. So the payments, the monthly payments to the financial institution needs to be serviced. The financial institution does need to be notified of the death, and they're probably going to ask what the plan is with the property, and of course remind the executor that the debt still needs to be serviced. Otherwise, unfortunately, it still goes under power of sale proceedings.
Okay. And I know every situation's different. So if this is not something that you can answer, totally fine. But what if the lender doesn't want to work with the beneficiary? Does that ever happen?
No, not really. They just care that they get paid. That's their most, and they wouldn't really have any other rights. If they get paid, I don't see why they don't really have a restriction unless, I mean, every case is different.
Yep.
And unless, for example, it's a different kind of lender, like a private lender or a B lender, and there's special provisions in the documents that the deceased would have signed with them when they took on the mortgage. But generally, I don't see that. Generally, like I said, generally the property is sold, the net proceeds are paid. But I have had cases where, for example, there's one beneficiary and that person wants to receive the property because they also live, for example, it's maybe a child and they also live with a parent, it's an adult child, and there's a mortgage on it.
Mhm.
And the child just pays off the mortgage because maybe the parent had life insurance and they use the life insurance proceeds to just pay off the mortgage, and then the property can be transferred in their name without a problem. Where somebody would have a say is where there would be more beneficiaries, and there's
Mhm.
it's not enough, the funds, the liquidity in the estate, it's not enough to pay the others gifts. That's when there would be people that would have a say on whether the property would be distributed. It's called in specie, is distributed as is or liquidated and sold. So if there are enough funds to pay one of the beneficiaries to pay their share, then no problem. The property goes to the other beneficiary. And it's also beneficiaries can decide, for example, what if they're equal beneficiaries to a will, and then one of them says, I really want the property, And then we calculate, well, what is that share? What is the fair market value minus whatever we need to minus expenses? And then what is the other beneficiaries share? And do they agree? Then we could do it like that, because most wills allow you to transfer property in specie if you want to. So
Perfect.
the trick is that if everybody gets along, that makes a huge difference. If they don't get along, then there's less options available, basically.
Got it. Okay. So tenants in common.
Tenants in common have have a divided interest in the property. So that means that a person can own 1%, 99%, 10%, 90%. The most common I see is either 50-50. For example, they're investors and they own 50-50, or 1% and 99%. That's because the 1%, the person with 1% was added to title for mortgage purposes. So when one of the tenants in common dies, the 1% dies. Let's say that share gets distributed in accordance with their will. So it does not go to the 99% holder.
Mm,
Um, and there's ways around that, but for the most part, that's how it works. And so whenever a person takes the 1%, it's, as a real estate lawyer, I always advise them to get a will, and I ask what is their intention with the 1%. Do they want it to go to the other person? Because if they do, there's ways around that. And so it's always better to think about this ahead of time. But short the short rule is that it's distributed in accordance with the will, with the terms in the will, or in accordance with the Succession Law Reform Act.
is that the same case if the 99% dies?
Yes,
Okay.
for the most part, unless there's certain exceptions put in place from before, thought out from before. There could be combinations of joint tenancy and tenants in common that could be on title. I'm not going to get into that because it could get complicated. But yes, generally, if you're a tenant in common, your share does not go to the other person. It just gets distributed in accordance with the terms of your will or in accordance with the Succession Law Reform Act.
Perfect. And then lastly, joint tenancy.
So joint tenancy has a right of survivorship. So that means that if one owner passes away on title, the other owner gets right of survivorship. The beauty of this is that it bypasses the deceased estate. It does not flow. It means that it does not flow through the estate. There's no estate administration tax payable. It doesn't count as an asset for estate administration or for estate administration tax purposes at the date of death, and it just goes to the survivor by right of survivorship. Very simple to do. Any solicitor who practices real estate law can help with this, but there are exceptions to this, such
Okay.
as family law considerations, and if any of the joint tenants would have severed the joint tenancy prior to death, or there would have been intentions for that. So I'm not going to get into that, but for the most part, it's popular among spouses, and the spouse just gets it by right of survivorship.
Okay. So obviously we understand sole ownership, got that. In terms of tenants in common and joint tenancy, that would be the difference between the two. The benefit of each has to do with what happens upon death.
Yeah. So tenants in common does not have a right of survivorship, and joint tenants has a right of survivorship. So they're not just it's easy, it's fast. There's no need to go through probate in a joint tenancy. It doesn't go through probate, and there's no state administration tax payable on it. These are the ramifications. But there's many reasons why people want to own as tenants in common as well. For example, common investors, a parent and a child. For different reasons, people choose to own it in this way.
Okay, gotcha. Okay. Is there something that people should know about each before deciding, do I do tenants in common or do I do joint tenancy?
That's a good question. It depends on what their situation is at the time. So oftentimes, For example, I have parents and children, they buy a property together and they say, oh, just joint tenants, everybody who want to be joint tenants has a right of survivorship. They don't realize that there's ramifications beyond that. But then as soon as I start explaining to them the difference between joint tenancy, tenants in common, and what are the ramifications on death? So if one of them were to pass away, for example, what if there is one child on title to help the parents qualify for mortgage? So, and the child is as added a joint tenant, but then the family has four more children or three more children. Then that one child, if the parent passes away, the one child gets the property by right of survivorship. That's not fair to the other children. So as
Mhm.
soon as they start explaining this to my clients, they start realizing that, oh, we didn't know about tenants in common. We didn't know that we could put the child with only 1%. Yeah, this is a lot more fair, like to our children, even though we trust our child who's on title to give money to the rest of the children. I suppose you never know.
Mhm.
And so I just like to open my clients' eyes and then they can decide whichever way they want to own it.
Got it. Okay. So can we kindly jump into for each tenants in common and joint tenancy, what happens in the case of a mortgage?
So if there's a mortgage on title in the case of joint tenants, it's treated similarly to sole ownership in that the mortgage needs to be serviced and then it needs to be paid before any title transfer can take place. So now with tenants in common, there's a reason why people are there as tenants in common. If they're investors, probably their lawyer would have recommended them to sign an agreement regarding what happens on death if the other tenant has a first right to buy the property and therefore pay off the mortgage. And so the proceeds can then flow through the estate of the deceased to the beneficiaries. Or if there is no agreement, then the mortgage does need to be serviced. So there can be no transfers of title or sale of half of the share of a property without having serviced the mortgage first. So the surviving tenant in common, and the executor of the person who passed away, they need to figure out how they're going to pay off this mortgage and what they're going to do with the property, half of the property on death. So that's tenants in common. And then for joint tenants, the spouse, well, it's usually, spouses own as joint tenants. So the spouse, let's say they go to the bank, they advise the bank that my spouse passed away. The bank is, in most cases, content to allow them to have a survivorship application done. So to remove the deceased from title and have title revert back to them fully, but keep the mortgage, which is treated differently than tenants in common or sole ownership. So the surviving spouse gets to keep the mortgage until the end of the term. And then they need to figure out whether at that point they need to either refinance and pay off the old mortgage and get a mortgage in their name, or they need to sell the property and pay the mortgage at the end of the term. But the most financial institutions allow this flexibility for the surviving joint tenant. But of course, they need to be consulted before anything is done with title.
Okay. Well, thank you so much for your expertise. If you guys have any questions, obviously Raluca is a wealth of knowledge and every circumstance is different. So please reach out directly. As always like, comment, and share. Thank you so much.